Mr. Paradkar.
Chief Justice McLaughlin, Justices, may it please the Court. Let me provide you with a roadmap of three fundamental areas that I'm going to cover in support of the correctness of the ruling of the Ontario Court of Appeal. The first area is the established principles that the mere presence of firearms, absent any other factors such as shots being fired, threats being made, or guns being connected to the commission of a serious offense, does not constitute exigent circumstances to allow police to circumvent the necessity of having probable cause. I intend to take you to the U.S. test, which has been adopted by Justice Doherty. The second area is that the initial stop was not justified under the roadblock test set out by Justice Doherty. The police had no reasonable grounds to think that stopping persons and vehicles that did not match the description of the 911 caller would result in the apprehension of those individuals or guns. And the third area is the correctness of the Ontario Court of Appeals Section 24.2 analysis. Let me get to my first area. The first area is that the mere presence of firearms does not constitute exigent circumstances. This is a question Chief Justice and Justice Bassarash raised. I intend to answer it. The United States Court of Appeals has repeatedly found that the mere presence of firearms or reasonable belief that firearms are present does not create exigent circumstances unless the government satisfies its heavy onus of proving three things.
Sorry, can we take into account the fact that firearms are not illegal in the United States?
Well,
And that context is therefore different?
Justice Abella, the issue here in the U.S. case law deals with illegal firearms and not lawfully possessed firearms. So the principles with respect to exigent circumstances would apply to this case. The three criteria that the police have to allow them to use the exigent circumstances test is A, they had information that the suspect was armed and likely to use a weapon or was violent. This is similar to the information that the police had in Murray, and for this proposition, I'm going to take you to the case of Bates at tab 3, paragraph 43 of my authorities when I get there. B, they had a justified belief that someone was in imminent peril of bodily harm and the search was not broader than necessary to ensure a protective sweep. Reference will be made to the United States Court of Appeals decision in Mason at tab 16. And C, they had a justified belief that the defendants are aware of police presence and are destroying evidence. The reference will be made to Dawkins. Justice Doherty's test for imminent danger is as follows. It's found at paragraph 55 of his decision. It's volume 1 of the record, page 68. Justice Doherty defines the test as follows. And he is articulating this test to carve out an exception for the police requirement to his roadblock test. He's not saying the police have to abide by or restrict the police from abiding by his roadblock test. Indeed, the third branch of the test is that police can rely on if they can rely on other investigatory means. There has to be a balancing. But he carves out an exception for police and says that the police need reasonable grounds to believe that anyone was imminent danger. The reasonable grounds requirement to establish imminent danger is fully supported by the United States Court of Appeals decision in Mason, Moore, Sealcase, and Williams. And this is the test that the United States Court of Appeals has set out, and I urge this court to adopt. These cases hold that officers must have an objectively reasonable belief that an emergency existed and where real, immediate, and serious consequences were likely to occur if the officer postpones his actions. Furthermore, they add in...
How immediate do those cases say it has to be?
This is the immediacy requirement with respect to, it's fact-specific. In some cases, let me give you an example. There was one of the cases had to do with a drug dealer using a shotgun to threaten a potential buyer. The buyer immediately goes to the police, reports that information, comes back. There have been other situations, so there has to be some temporal connection. In terms of defining the immediacy, in terms of time, I think it's fact-driven. Whether it's 3 minutes, 10 minutes, 15 minutes. I'll give you another example, which I intend to get through. There's a rocket launcher case. There's a case that involves police initially receiving information that an individual has firearms. So a couple of days go by, they get a search warrant. The individual then comes back and says, by the way, I have information the individual has a rocket launcher. They immediately then execute the warrant, violate the principles of knock and announce. The reason for that is the uniqueness of the weapon, and I intend to give you that because that's an exception to guns in the United States case law. So the immediacy criteria is fact-driven on a case-by-case basis depending on what the facts are.
I appreciate that you obviously say there's no emergency here, and so maybe my question isn't really fair, but I'm wondering how a police officer would determine when you're dealing with semi-automatic weapons and you don't know whether they're legal or illegal, what should go through that officer's head in determining whether or not there is a likelihood of imminent or not imminent use, and so it does or doesn't require emergency measures such as a roadblock. I guess, and the subsidiary to that is the question that's been asked before this morning, and that is, what benign use do you think gets weighed against the possibility of risk? And then the other aspect is, are we allowed to take into consideration, as the Chief Justice indicated, the fact that in this particular community, there had been a number of violent incidents involving the use of guns?
To address that question, Justice Abell, is to look at the objective foreseeability that a reasonable police officer, an experienced police officer would have had. The U.S. cases demonstrate there has to be something more than the presence, a threat associated with the presence, use associated with the presence. So there has to be some other factual basis tied to guns that leads into exigency, raising the level of presence or possession of firearms to exigency. And I would plan to demonstrate 4 or 5 cases factually how the United States Court of Appeals has elevated in those circumstances. For example, if somebody was using a firearm, there was a call that somebody has been kidnapped, somebody been held hostage. In those circumstances, you have that level of urgency. The other thing is, in this particular case, I say there are no exigent circumstances, or let me put it this way, the exigent circumstances were somewhat undermined by 2 things, 2 factual bases. Don't forget, there was an initial police officer who went on the scene, said he did not see anyone with guns outside the $1 Million Saloon. He saw people mingling around and no firearms. So in my respectful submission, that information, both officers were asked in cross-examination, you had that information, they said yes. They knew on radio call that no one was seen outside with firearms. That's number 1. Number 2, the officers are asked, this is not a gun call about shots being fired or somebody being injured or threats, and they agreed with that. So I hope I've answered that question. I intend to demonstrate that in the examples that I'm going to give you, Justice Bell, and the court. In this case, dispatch relayed to officers that there were 4 men with guns, and as I've just stated, there's no corroboration that the initial officer saw anyone with guns. That would have elevated it. They might have elevated it, certainly, if the officer had seen individuals with firearms in front. That may have elevated because that's one piece of corroboration. Number 2, and I've already stated about this is not a case about threats and so forth. I think at this point I just want to address one issue that the appellant raised before I forget. The appellant said, well, there's really, this is not a case about vehicles, this is individuals. In terms of, she said the men were associated with vehicles. At this point, I'm just going to give you these references so you have it. Volume 2, page 293 and 297. The dispatch tells the police they came in cars. The 911 caller was specifically asked, are they with a vehicle? And he responds yes, and he describes the vehicle. So to address my friend's point that they did not have individualized suspicion with respect to vehicles, they did. Let me get back to what my conclusion is and how Justice Doherty was right. Justice, in this case, this does not satisfy the test under U.S. case law that requires an objective belief that a reasonably experienced officer had that there was an emergency. This accords with Justice Doherty's finding that police need reasonable grounds to believe there was imminent danger. The Crown in its factum and oral submissions had said this case boils down to imminent danger and safety concerns. I will now take you through the U.S. case law